Good day everyone. I am here to discuss what is international law and practices. International law is the set of rules, agreements, and treaties that are binding between countries. So international law daw po, it allows us for the practice of stable, consistent, and organized international relations between different countries. So international laws generally comes from three sources, and these sources are treaties, custom, and general principle of law. So, yung treaty, ito daw po yung binding formal agreement, contract, or other written instrument that establishes obligations between two or more subjects of international law. Yung custom naman po, ito yung source of law that involves the study of a number and its aspect. So, yung importance nito ay yung recognition and classification ng various theories and distinction with prescription and usage and essential ng isang valid custom. So, yung general principle of law naman, these are the basic rules whose content is very general and abstract, sometimes sometimes it's reducible to a maximum or a simple concept. So, yung sources daw ng international law, yun daw ay nare-recognize by most of the national and legal system. Treaties are express agreements that countries enter into voluntarily, and they are written agreements. When a sovereign states enter into agreements that are binding and enforceable, it is called international law. So, yung country daw na punta dito to make binding rules that they believe na nagbe-benefit sa kanilang citizen. So, yung international laws promote peace, justice, common interest, and trade. Parang yung sa ASEAN, yung ginagawa nila. Ganun yung parang ginagawa ng iba't ibang country. Nakikipag-bind sila sa ibang countries para sa ikabubuti ng mga citizens nila. Tapos, international lawyers. International lawyers are skilled writers, speakers, and negotiators. They appear as representative of their countries. They work on behalf of elected officials in order to help them understand their country's rights, duties, and options. So, yung international lawyer naman, they help the elected leaders put their ideas and plans in writing international and multiple languages. So, next is treaty. Treaty means an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. So yung treaties, these are the principal source of public international law. Treaties can be bilateral or multilateral. Bilateral, yun daw yung between two states, then multilateral between three or more states. Next is Vienna Convention on the Law Treaties. The UN agreement that codifies the rules that guide treaty relation between states. The convention provides an international legal framework for this relation in time of peace. So, yung treaties, they will enter into force when it has been signed and approved by a certain number of parties. Parties to a treaty may ratify a treaty with reservation or other declaration unless the term of the treaty place restriction on those actions. That would be all. Thank you.
Good morning, everyone. I will report about the treaty. So, what is treaty? Treaty is an agreement of two states that can have a rights and liabilities that governed. There are two types, which is bilateral and multilateral. So what is bilateral? Bilateral is a treaty between two states. It is also called bilateral, or one that entered of large number and direct on international law. And bilateral has a that mentioned the obligations. What is the examples of bilateral? First example is Camp David Accords that signed in 1978 between Israel and Egypt and comprises with 292 states. Now let's proceed to multilateral. Multilateral is entered number of the states within separately signing of this treaty. So, 2 or more siya. So, what is the examples of multilateral? Multilateral is non-proliferation treaty is a multilateral treaty. And one of the examples of multilateral is non-proliferational treaty. It is a multinational that composed of 219 states. 189 states that signed. Sorry. What is the process of treaty making? Process of treaty making, there are 5 types. Articles, it is a text that delivered to the members of this treaty or agreement. So what is the 3? Resolution, recommendations, and opinions. Resolution is also mechanism that held in a conference that instructs. Recommendation, it is more to give suggestions, and there's no legal. Opinions, when you in a meeting or in a agreement, it is very important to give your opinions to give away to conference. That's it. Thank you.
So, treaties are divided into 3 parts. First is the preamble. This is somewhat informal, setting out the names of the parties to the agreement, the names of plenipotentiaries, and the object of the agreement. Like this one, Republic of X and the Kingdom of Y desiring to facilitate. Ito yung names of the parties of the agreement. That is the object of the agreement, desiring to facilitate of have appointed as their plenipotentiaries for this purpose. Such things like that. The next one is the terms and substance of the agreement, substantive clause. Sa pagkakaintindi ko, ito yung part na kung ano yung reason, kung ano yung legal reason kung bakit nila ginawa yung treaty na yun, and kung ano yung mga certain na objectives nila sa treaty na yun, kung ano yung pagkakasunduan nila, kung ano yung reason kung bakit nila ginawa itong treaty na to, mga ganun. Then do sa last part ng treaties is the administrative clauses or final clauses. Ito yung mga protocols or yung mga provisions na naka-include dun sa isang treaty. Kagaya na lang nung the date and method of entry into force of the treaty. Kung minsan kasi wala naman talagang specific na date kung kailan magiging valid or magiging mag-occur o yung isang treaty. Minsan para magkaroon ng puwersa or yung mag-entry into force yung isang treaty. Then yung the duration and method of termination of the treaty, definition of terms, the method of settlement of any dispute, reservation, accession to the treaty by other states, amendment or review. Yung accession to the treaty by other state is yung kung accessible din ba siya sa ibang state or pang sa kanila lang. Kunwari kung pang multilateral siya or para lang sa kanilang dalawang specific na party. Then, the language of the treaty, which are to be authoritative, ratification, and deposit of instrument of ratification, registration with the United Nations, and invariably date and place of signatures, and sometimes seals of plenipotentiary. Siyempre sa mga treaty mahalaga yung signature kasi yun yung parang nagbibigay ng batayan para malaman na pinagkasunduan ngayon na may consent, nandun yung consent kapag may signature nung dalawang party or ng mga plenipotentiary nung dalawang party yung itong treaty na to. So, it is essentially a contractor between states, and its validity may theoretically be challenged by one or more of the parties concerned in various grounds, which are 83 of the Vienna Convention on the Law of Treaties. These are: first is the error relating to a fact or situation which was assumed by the state concerned to exist at the time when the treaty was concluded, in which form an essential basis in its consent to be bound by the treaty. This itong mga bagay na to is yung coscogens, basta yung ganun, coscogens. Treaties conflicting with peremptory norm or of general international law. Yung validity ng isang treaty ay challenge kapag do sa mga kapag pumasok siya do sa mga tinatawag na coscogens, yun yung mga bagay peremptory norm ng general international law. Yung international law natin nanggagaling kayo siya sa peremptory norm, na kung saan yung mga peremptory norm is yung mga pinagkasunduan or napagkasunduan ng mga kasama dun sa United Nations, sa international community. Yun yung norm na napagkasunduan nila na kunwari bawal yung ganito, bawal kung ano man. Yun yung mga yun yung peremptory norm, siya yung batayan ng international law na ito yung mga accepted and recognized by different states in international community. Itong mga ganito, yung validity ng treaties is nawawala kapag pag pumasok siya sa mga bagay na to. Yung sa mga pagka naging salungat siya sa mga peremptory norm ng international law. Then itong peremptory norm, hindi to basta-basta na wawala or mapapalitan, not unless kung magkaroon ng another norm or mag-propose ulit ng bagong mapagkakasunduan yung mga nasa international community na okay, ito yung bago nating ito yung, di pa rin nawawala yung pinaka same character or same parts dun sa unang naging norm nila. For example, respect for human rights. Kung yung isang treaty ay medyo hindi respect for human rights o hindi nirespeto yung human rights na which is nasa peremptory norm na napagkasunduan ng mga ng mga estado sa international community. So hindi na siya agad valid kung yung treaty na yun umagain sa pag-respect sa human rights.
Hello guys, let's discuss about the termination of treaties. Treaty may legitimately come to end by agreement of both parties. First, by expiration of the time limit provided in the treaty. By the parties making use of termination clause provided in the treaty. First daw po kung ano daw po yung term lang ng treaties na yun. Kunyari, 2020 to 2021. Pagka nasa 2021 na siya, pwede na siyang ma-terminate. Pwede na po siya maging walang bisang, mapawalang bisa. Next naman po, pagka violate sila ng mga termination clause. Yun po yung dalawang possibilities para maging hindi naman pawalang bisa na yung treaties ng dalawang state. Yun naman po, yung absent of this provision may be unilateral, abrogated, or denounced. Varying degrees of legitimacy can be claimed for such unilateral action in the event of first, fundamental change. Fundamental change having taken place in the circumstances which existed at the time of the treaty was drawn up. Next naman po is the extinction of other contracting party as a state in a bilateral treaties naman po ito in such a way that the successor state does not inherit rights or obligations under these treaties. Next is the outbreak of war. Next po is the denunciation of multilateral treaties. Then by such a number of parties as to render the treaty inoperative. Next naman po ay a material breach of the treaty by another party to it. Yan po yung mga varying degrees of legitimacy can be claimed for such unilateral action in the event. Let's talk about the political asylum and the extradition of criminals. International law traditionally relates to political asylees. Let's talk about the political asylum and the extradition of criminals. International law traditionally relates to political asylees. Two categories of political asylum is first, territorial asylum. Ito po ay granted by a state to an alien in its territory. The second naman po is extraterritorial or diplomatic asylum in the premise of a diplomatic mission or other such premises entitled to inviolability. A state has the right to grant asylum to aliens within its own territory. Extradition has been made in respect of crimes against internationally protected person. That's all. Thank you.
Hi guys, so this is Franz. So I'm gonna discuss about diplomatic asylum quickly. Let's discuss it quickly. So diplomatic asylum is as you've heard, there are two kinds of asylum, territorial and extraterritorial. But I'm gonna discuss diplomatic asylum. So the term diplomatic asylum in the broad sense is used to denote asylum granted by a state outside its territory, particularly in its diplomatic mission. So, diplomatic asylum or asylum in legation is more commonly given in delegation. So, how is that and why is that? So, a person can be granted a diplomatic asylum by a state if he or she is if her or his life is in danger. So there are many certain requirements to be able given by a state diplomatic asylum, but most commonly is her life is in danger. For example, political activists, political persecuted person here in the Philippines has been given by a foreign country a diplomatic asylum. It's like that. So, one note to be remembered, some countries doesn't practice diplomatic asylum. One is India, and this diplomatic asylum is controversial, and it can only be negotiated with diplomacy. So it's a controversial type of asylum. So there are an asylee. So I'm gonna read some requirements, or what should an asylee do. Asylum is inviolable only for those accused of political crime. So political activists most common. So a person who has committed a criminal act will not be granted asylum, of course. So the chief of legislation when political asylum is sought is obliged to notify the Ministry of the pursuing state and to request a safe conduct beyond the national territorial. So why give diplomatic asylum? It's for protection or shelter. So that's the sense of asylum, right? So the asylee is not allowed to what's that? Sorry, it's not allowed to act controversy to the public peace. So that's one. So one important key point to remember about asylum is it is the right of a state to grant asylum for an individual, but it is not the right of an individual to be granted asylum by the state. So it is the right of a state to grant an individual an asylum, but it is not a right of an individual to request or to request an asylum. So that's it. I hope you learned something from this 4-minute and something video. So thank you and God bless.
Okay, extradition is the forcible removal of a person from one state to another to stand trial or suffer imprisonment for alleged offense. Example is, State A receives a request from State B to return an individual to State B so he can appear for trial. Yung isang tao, may ginawa siyang krimen dun sa State B. So, pwedeng mag-suggest yung pagka tumakas yung criminal sa nation sa state ni State A, pwede sila mag-request ng extradition para may return yung nag-commit ng crime sa State B. Tapos, request for the extradition arises when a person who is accused or convicted of criminal offense seeks refuge in another state. Yun nga, pagka tumakas yung criminal na nag-commit ng isang krimen sa isang lugar, pwede mag-request ng extradition. Tapos, application for extradition are made through diplomatic channels and are reasonably straightforward where both states have to agree to specific principle in advance through the medium and extradition treaty. Ito man, pagka ganito, yung parang may mga agreement na rin naman yung mga tao. Pagka alam nilang may wanted dun sa lugar nila, tapos na-inform sila, automatic na rin naman nilang isesend or ibabalik yung criminal para ma-judge nung nagre-request ng extradition. Tapos, extradition shall not be applicable. Ito. The offense is related to political offense. Tsaka, if the offense are targeting the person's nationality, race, religion, and his political opinion. Ito naman, hindi naman, kunyari, yung criminal, wala naman siyang ginawang kasalanan, ano lang siya, parang diname up lang siya. Pwede siyang yung extradition na nag-request ng, kunyari, yung si State B, nag-request siya ng extradition kay State A, tapos piniprame lang naman ng State B yung, piniprame ng State B yung criminal na nasa State A. Pero yung State A, pwede siya lang i-refuse yung extradition na ginawa nila. Kasi dinidiscriminate yun. Tsaka yung political offense, parang gusto lang nilang matalo sa politika yung parang kung sino mga nagpo-control din sa kriminal. Tapos, type of political offense where extradition shall not be applicable. Yung extradition hindi pwede. Yung pagka yung an offense where the representative is threatened and an offense where national security is threatened. Ito naman, siyempre, alam naman natin pagka ganito, mga terrorista, marami silang natathreaten, security na ng buong state to, hindi na natin siya kailangan extradition. Pwede na siyang i-judge agad kasi, or i-judge ng sariling nasa territory nila para ma-judge na lang. Yun. Extradition, parang ano lang, yung naging wanted lang isang tao tapos parang nag-post lang sila noon, poster niya. So, pagka nakita ng isang state, pwede siyang i-request or may balik sa state para judge yung kaso niya. Yun lang.
Recognition of state and governments. Recognition comes about by a unilateral declaration, and it can be explicit or implicit. For a state to exist in international community, it must be recognized by other states. And once na binigyan na ng recognition at maging recognized na yung state or yung government, ay bibigyan na sila ng rights and privilege granted by international law. Recognition of government is different from recognition of state. Para ma-recognize as a new state, kailangan magkaroon ng essential attribute of state such as the population, territory, government, at capacity para makapasok into relations sa ibang state, and if the government later changes, it may not be recognized even though recognition of state continues. Kaya, once na ang recognition ay binigay na sa state, yung recognition na yon ay hindi na pwedeng tanggalin pa or alisin pa. Pero yung recognition ng government ay opposite ng recognition dun sa state. Example na lang natin ay yung leaves is the government and tree is the state. Kahit na yung leaves na yun or yung government na yun ay matanggal pa or mawala, yung tree or yung state ay mananatili pa rin andun. And according to international law, recognition ay isang formal na pagkilala sa status ng independent state sa pamamagitan ng iba pang umiiral na estado. And theories of recognition. This is the purpose of understanding the nature of recognition. There are two types of theories of recognition. Number one is the constitutive theory. According to this theory, personality of state is created not by fact but through recognition by other state. It is a process by which a political community acquires personality and becomes a member of the family of nations. Number two is declarative or evidentiary theory. According to declaratory theory, a state comes into existence in international law as it requires all attributes of statehood. It only provides the evidence to this fact. That's why it was called evidentiary theory. And then, form of recognition of state. There are two types. There are two forms of recognition of state. One is the express recognition. Grant is expressed in written words. Ito yung kapag yung existing state ay gustong kilalanin yung iba or kabila pang state sa pamamagitan ng express recognition ay Nagbibigay sila ng public statement sa pagbibigay ng or sa pamamaraan ng pagbibigay ng diplomatic letters or notes, statements, and telegrams. And then, number 2 is implied recognition. It it does not release a formal state by some acts which imply the states is being recognized. It is opposite ng express recognition dahil yung implied recognition ay nagpapadala sila ng representative to attend ceremonial functions and etc. State is participate in multilateral conference or treaty in implied recognition. And then, two kinds of recognition. Number 1 is de facto recognition. It is a temporary recognition. It can be withdrawn by other state at any time. It is no exchange of diplomatic representatives takes place. Ito yung mga pangyayaring hindi agad-agad pinahihintulutan. And sa de jure recognition naman, number 2 is de jure recognition. De jure recognition, it is a permanent recognition which one granted cannot be taken back or withdrawn by other state. De jure means according to law, kaya ito ay lawful recognition. It is opposite ng de facto recognition. That's all.
Good day everyone. Ang report ko po ngayon, ang topic ay tungkol po sa sovereignty and its extent and jurisdiction from outside its territorial lands. So, sovereignty means independence or freedom from outside control in the conduct of the domestic and foreign affairs of states. So, napakasimple ang ibig sabihin nito. Ito yung isang kalayaan ng isang estado sa kontrol ng ibang bansa or hindi siya na napapakailaman dito. So, its extent and jurisdiction. The territory of the state extends over the land within the state frontier and space above it, but not upper air or outer sphere. So, ang extent or yung pinaka layo or limitations ng isang sovereignty ay masusukat sa outside capacity ng isang land or lampas ng land. Ito yung tinatawag na nating sa seas. So, pagka sa seas naman or yung sa below underground din, meron din siyang certain na sukat lamang para ma-determine na under pa rin siya sa isang sovereignty or jurisdiction ng isang bansa. So, yung kung ipag-aano naman natin sa above surface or sa sky na tinatawag, meron din po yung sakop din po yun ng sovereignty pero hindi po siya aabot ng outer space. So, in the case of maritime states, sovereignty also extends within certain limitations over the internal waters in territorial sea, and the state as a measure of control over the contiguous zone, the exclusive economic zone, and continental shelf. So, madidiscuss ko rin dito yung sa tatlong tinatawag na nating mga zones or parang maka-claim as a part of sovereignty. Dito yung contiguous zone, exclusive economic zone, and continental shelf. So, nabuo itong tatlong to na mga zones para matawag natin silang sovereignty ay dito sila binase sa 1958 Geneva Convention at 1982 Law of the Sea Conventions. So, ito yung mga pinaka-major provisions sa mga conventions na ito. So, the provisions of these are as follows. Coastal state exercise sovereignty over the territorial sea up to 12 nautical miles in extent, but foreign vessels are allowed innocent passage through these waters for purposes of peaceful navigation, and permission to overfly is subject to the approval of coastal state. So, ang ibig sabihin po ng coastal state, ito po yung state kung saan ang isang gobyerno ay namamahala sa isang territorial waters. Kung ikukumpara natin to, ito po yung sa Pilipinas at yung sa may West Philippine Sea. Ang coastal state po ng dalawang yon ay under po siya sa Philippines. Tapos yung sa dagat naman po, yung sa South China Sea or West Philippine Sea ay yun po yung sa territorial sea na tinatawag. So, pwedeng dumaan dito ang isang barko sa kung meron lamang siyang permission. Permission po to be granted by the coastal state. Ito po yung tinatawag na innocent passage. Or pwede silang dumaan dito. Pwede naman silang dumaan, hindi naman sinasabing hindi pwedeng dumaan. Pwede silang tanggihan or payagan dumaan sa isang territorial sea basta sila po ay makakuha ng permission within coastal state. So, depende po yun sa coastal state kung i-deny nila yung entry or i-allow po nila. Isa po yun sa mga major provisions. The next, ships and aircrafts of all countries are entitled to transit passage through straits used for international navigation as long as they proceed without delay and without threatening the coastal state. The states bordering the straits will be able to apply generally accepted international regulations and pollution control but may not hamper or impede transit. So, meron ding tinatawag isang provisions yung mga aircraft at mga ships ay pwedeng dumaan. So, ang tawag dito ay tinatawag na transit passage. Ito, ibig sabihin nito, nadadaan lang sila yung within may transfer. Kunyari, may isang foreign vessels na dadaan. Kunyari, ang foreign vessels na to ay ang destination niya ay South Korea. So, dadaan siya ang barko sa Japan bago makarating ng South Korea. So, pwede siyang dumaan sa territorial seas ng coastal state ng Japan. Basta dadaan lang siya na without hampering any violations, allowed siyang dumaan nun. O, that ship is entitled for the right of transit passage. Ito namang archipelagic state made up of a group or groups of closely related islands and interconnecting waters have sovereignty over the sea enclosed by straight lines drawn between the utmost points of islands. Ships of all other states enjoys the right of passage through sea lines designated by archipelagic state. So itong archipelagic state ay tinatawag siya mga pulo-pulo, yung mga pulo-pulong isla. So ang pinaka the best example diyan is yung Philippines. Ang Philippines ay nahali sa tatlong major na pulo, Luzon, Visayas, Mindanao. So itong archipelagic state ay meron siyang pinaka-territory dito sa loob na yun. Tapos lahat ng ships doon na entitled dito sa Pilipinas ay pwedeng dumaan doon sa mga line na sinukat nila. Pero kung ang mga foreign vehicles naman ay dadaan doon, syempre they need permission pa rin sa coastal state para makadaan. Siyempre, right pa din ng coastal state na i-deny yung kanilang pagdaan. Yun. So, ito naman, yung sa coastal states, susukatin naman kung hanggang ilan yung measurement ng coastal states o yung extent ng kanilang jurisdiction. Coastal states have sovereign rights in a 200 nautical mile exclusive economic zone or tinatawag nating EEZ with respect to natural resources and most economic activities and also entitled to have a certain degree of jurisdiction over scientific research, environmental preservation. All other states have freedom of navigation and overflight in the zone as well as freedom to lay submarine cables and pipelines. Although, when coastal states cannot fully utilize the research available, they should provide access for the other states with a certain preference for landlocked states. So, ito nga yung sinatawag nating example nga ng sakop ng ating EEZ or 200 nautical miles jurisdiction ay ang South China Sea or tinatawag nating West Philippine Sea. Yun po ay territory natin. Ibig sabihin lang po nun, nasa atin lahat ang natural resources nakalagak doon. Lahat ng pwedeng economic activity, research man or experiment na pwedeng gawin ay pwede natin gawin doon kasi territory natin yon. Pero ang nakalasaan sa provision na dito, kung hindi kaya ng isang coastal state na budgetan or mag-finance sa research dito ay dapat pwede niyang hayaan or bigyan permission ang ibang bansa na makapag-research dito sa mga territorial seas na hindi kayang anuhin ng coastal states. So, itong coastal states have sovereign rights over the continental shelf or the natural area of the seabed. So, itong continental shelf, ito yung sa mga pinakababa, yung sa mga coral reefs. Ito na to, sa seabed coral reefs. Yun din ay pag kunyari, kung sakop siya sa 200 nautical miles, ang syempre 200 nautical miles pa din ang kanyang pinakasakop. For the purpose of exploring and exploiting it without affecting the legal status of the water or space or airspace above, the shall extend at least 200 nautical miles from the shore and up to 350 nautical miles under specific circumstances. So kung sa layo galing shoreline to territorial seas, it extends up to 200 nautical miles. So sa under naman nito, underwater, 350 ang specific allowed jurisdiction ng isang bansa. So pag baba pa ng 350 nautical miles under sea level, ay wala nang control or jurisdiction ang bansa nun. So ibig sabihin may freedom na dumaan doon below 350 nautical miles nga lang. So meaning to say kung naka 400 nautical miles below seawater level ka, pwede kang dumaan doon. But under 350 nautical miles ay nasa jurisdiction ka or may rights ang coastal state doon sa seabed. The 1982 Convention provides for the elimination of overlapping shelves in terms of identical with those relating to the EEC. So, isa rin to sa mga provisions ng 1982. Dito yung masusukat yung mga disputes ng tungkol sa mga specific territory, kasi ito yung kalimitan na pinag-awayan ng bansa, yung kanilang territory sa seas, yung layo. So, noong 1982, nag-set sila ng standard na layo ng territory ng sea per countries. Iyon. So, basahin natin isa-isa. All states enjoy the traditional freedom of navigation, overflight, scientific research, and fishing on the high seas. They have the obligation to adopt or cooperate with other states in adopting measures to manage and conserve living resources. The territorial sea, the exclusive economic zone, and the continental shelf of islands are to be determined in accordance with rules applicable to land territory. But rocks which cannot sustain human habitation or economic life will be no exclusive economic zone or continental shelf. So, discuss natin yung sa una, all states. Ibig sabihin ito, lahat ng bansa ay may kalayaang maglayag, lumipad, at mag-research sa kanilang mga seas or territorial seas, or pwede dito sa tinatawag na high seas. Itong high seas na tinatawag, ito yung sa mga oceans or sa mga malawak na yung sa mga oceans, yung sa high seas. Ibig sabihin ito na yung free navigation na tinatawag, yung sa mga Pacific Ocean yan, pag dumadaan may meron yan, yung mga high seas na tinatawag. Yung mga oceans na yan or seas ay pwedeng maglayag kahit na sino, walang nagbabawal sa kanila. Lahat ng mga bansa ay pwedeng dumaan dyan, maglayag or mag-research, pero dapat lang nilang i-adapt yung mga measurement para may bawasan ang pollution or kung ano man yung makakalat nila doon sa kanilang research. So, dito naman sa territorial seas, hindi ma-determine na isa siyang territorial sea kung wala ito siyang human habitation or wala siyang exclusive economy within sa isang shelf or island man yun kung tawagin. States bordering enclosed or semi-enclosed seas are expected to cooperate in the management of living resources and on environmental policies and activities. Landlocked states have the right to access to and from the sea and enjoy freedom of transit through the territory of transit state by all means of transport subject to agreement. So, ito pa rin nasasabi sa provisions, lahat may access sa mga landlocked seas but with meron pa rin siyang permission granted from the coastal state or ito yung state na may isang exclusive jurisdiction sa isang seas or isang habitat ng island. And this may tinatawag tayong parallel system. It is amended in 1994, provides for the exploration and exploitation of the international seabed area. All activities in the area are deemed to be under control of the International Seabed Authority, which is responsible for supervising the recovery of minerals from the seabed. So, itong parallel system na ito yung mga namamahala dito sa mga paggamit or pagkuha ng mga resources under the sea, tinatawag sa mga coral reefs or pagkuha man yan ng langis. Dito nakikipag-cooperate ang mga iba't ibang bansa para sa kasiguraduhan na hindi gaano masisira ang mga natural resources doon at mapoprotektahan pa rin yung environment.
Hi, I am Lorena Levenza and I will be discussing about international jurisdiction and nationality. So, jurisdiction refers to the power of state to affect persons, property, and circumstances within its territory. So, international law particularly addresses questions to criminal law and essentially leaves civil jurisdiction to national control. So, meron tayo territorial jurisdiction. Sa territorial jurisdiction, merong dalawang principle, which is Ate Lai! Wait. Nagpi-video ako. Ayan, so meron tayong dalawang territorial jurisdiction principle, which is subjective and objective principle. So, sa subjective principle, it was exercised by the state where the offense is started. Tapos, sa objective principle, is the state where the offense is completed. So, ganito yan. Example, smuggling. Smuggling, kapag subjective principle from country A, doon nag-start yung smuggling and doon galing yung smuggled goods. Tapos sa objective principle naman is doon mapupunta yung doon na country, sa country B mapupunta yung smuggled goods. Yan. Okay. Next is according to the according to the territorial principle, states have exclusive territory to deal with criminal issues arising within their territories. This principle has been modified to permit officials from one state to act within another state in certain circumstances. So, ayan. International jurisdiction, it also allows any state to punish international offenses abroad. Ayan. So, let us proceed with nationality. So, nationality permits a state to exercise criminal jurisdiction over its nationals with respect to their extraterritorial conduct. So, meron tayong tinatawag na extraterritorial jurisdiction. Dito, so ito yung legal ability of a government to exercise authority beyond its normal boundaries. And so, sabi din dito, nationality principle permits a country to exercise criminal jurisdiction over its nationals accused of criminal offenses in another state. So, vice versa naman ngayon. Ang nationality principle, meron ding permission yung isang country to exercise criminal jurisdiction over a national that is accused uh, of criminal offense sa ibang country. Next is, if a state expels a person from its territory, only the state of which the person is national is obligated to receive him. Okay, so nationality is a commonly regarded as inalienable right of every human being. So, necessary, sabi sa is, hindi matatanggal sa isang tao yung nationality. Kaya nga, nag-state ang UN Declaration of Human Rights that everyone has the right to nationality and no one shall be arbitrarily deprived of his nationality. So, ayan. No one shall be arbitrarily deprived of his nationality. And that sums my report. So, on behalf of my team, of my group 3, we hope that you learn from our group, and thank you and God bless us all. Keep safe.